So we've got Nick and Ben from Locke Lord. So Nick's going to talk to us first about employment, and then Ben is going to jump in with intellectual property. So when you guys are ready, let's crack on.
Thanks. So I'm Nick Dent, a partner in the employment team at Locke Lord. What I wanted briefly to talk to you about is a few key decision points at an early stage of development of a new tech business and what you might want to be thinking about. A few bits on documentation, less interesting but important, and then a few culture issues. So in terms of template contracts, what should you be most concentrating on? Notice periods, obviously important. Covenants, IP, confidentiality are really the key three items. For IP and confidentiality, you should have standard but comprehensive provisions, and you should make sure that you cover not only your employees with these, but also self-employed contractors, people on outsourced arrangements as well through your contracting with them. On confidentiality, I'd say it's particularly important. Yes, by all means take a standard definition, but then do look at it in the context of your business and add in those things which you really care about, the key crown jewels of your business. Refer to them specifically. I had a case in the High Court just before Christmas trying to enforce confidentiality obligations, and it was hugely helpful that the specific things we were saying this guy was nicking from us were specifically name-checked in that confidentiality obligation. As regards restrictive covenants, obviously what is covered is things like solicitation and dealing with clients, poaching and hiring your employees, suppliers, interference with suppliers, and perhaps a blanket non-compete. You can't work for a competitor at all for a period. That last is not going to work for all employees, but for certain types of employees, particularly senior management, it may well be important. You want to think about whether you have kind of two classes of employees, junior and senior, with different levels of restrictions. If you do that, then you need to remember when someone gets promoted to put them up to the higher level. If you don't do that and you have a single form of contract, you should still get people to reiterate their covenants when they get promoted, because that helps on the enforceability. You also need to think about how your covenants interact with the leaver provisions in any share incentive arrangements, option arrangements, and perhaps make an event of default on the option arrangements somebody who breaks their covenants after they leave, even if they've been allowed on leaving a good leaver status. At some stage in your development of a company, you're going to want to formalize your set of policies into an employee handbook. Tends to be around the sort of 50 employee stage. And finally, on this point, think about people you think you're engaging as independent contractors. Often, if they're quite embedded in your business, the employment law and the tax law will not really consider them to be independent, but to be employees with the consequences that might bring. Then, very brief canter through some cultural issues which you want to think about. These might go to risk of employment claims, but actually, of course, it goes wider than that. So think about diversity in hiring and in promotion. There's lots of studies which say that this isn't just a good thing to do. Diversity of thought gets to better decision making, gets to, frankly, more profitable companies. Think about the way you manage performance. Professional, prompt, whether it's negative or positive feedback. And also think about how you use probationary periods. For someone who just isn't right for the organisation, doesn't have the right skill set, then you are likely to be able to part with them in a reasonably amicable fashion if you say you just haven't passed your probation. Much more likely to get difficult and contentious if you don't do that. Think about if you're an owner-managed business, you are probably at an increased risk of perceptions, at least, of bullying, of maybe even Me Too issues, because the owners are all powerful in this small organisation. And so you need to think also about your speak-up culture, whether people feel able to come forward if there are things that they see which aren't quite right in their view. Think about the balance between presenteeism and universal home working. Both ends of the spectrum can be problematic and just need to be managed thoughtfully and sort of with openness and clarity. And finally, we've heard some talk about funding rounds. So as a business develops, brings in new investors with successive funding rounds, different profile of investors, the culture of the organisation, the culture that the investors, the owners, the new owners of the business are going to expect will change over time, probably an increase in formality over time. And as a business, you need to be conscious of that and you need to manage that process actively. That was all I was going to say for now. Ben.
Thanks, Nick. So my name's Ben Hitchens. I'm a partner in the intellectual property group at Locke Lord. I work with clients, including startups, on devising protection strategies globally in relation to IP, as well as enforcement against third-party rights. What I'm going to try and do today, it's a lot of information to cram into 6 minutes, 45 seconds, but I'm going to try and give you an overview of the key IP rights as far as they relate to your businesses, and we'll finish off with some pointers in terms of IP created in the workplace. So as a starting point, when I sort of talk about IP, intellectual property, I mean sort of expression of originality, novelty, distinctiveness, some form of creative contribution, really. IP rights fall broadly into 2 buckets. You've got registered rights, which are trademarks, patents, registered designs, and you have unregistered rights, like passing off copyrights and also unregistered designs. The registered routes usually attach, there's a formal fee attached and there's a process, whereas unregistered rights subsist automatically, depending on the sort of satisfaction of various criteria. IP rights can cover all sorts of things: slogans, logos, trading names, the get-up of websites, for instance. It's a very broad collection of rights. So when we're talking about protection of names, protection of logos, even some distinctive slogans, what we're looking at really is trademark law. And trademarks are great because they can last indefinitely, subject to renewal. There are certain criteria that you need to satisfy to register. So a trademark ultimately has to be a badge of origin, has to be distinctive, has to designate the goods and services offered under it. And that means a trademark can't be descriptive and it can't be generic. So if I try to register the trademark soap for cleaning products, it would be refused. And likewise, the term escalator used to be a brand name and it fell into generic use, so it would obviously no longer be a suitable trademark. So if you think about a trademark like Amazon, for instance, which has no relationship to the underlying goods and services, that's quite a strong trademark from a legal perspective. And talking to some of you, obviously we're UK based, but maybe with some European focus, I would say the best option would be to secure a European trademark. That covers all 28 member states of the European Union, and even the UK after Brexit, there'll be a separate converted right which will be created, and that will allow you to prevent anyone with an identical or similar trademark anywhere in the EU from using that trademark. So Romania, Slovakia, Slovenia, wherever you choose. So it's obviously a very powerful tool. The key thing for trademarks to always remember is that the filing date is key. So you need to get on the register as soon as possible. If you are using a company name and someone else already has a trademark similar or identical to that name somewhere in the EU, potentially they could prevent you from using that name and you could be slapped with an injunction. Similarly, even if you've started using earlier than a registered right, there are only limited defences available to prevent an injunction in those circumstances too. So the key thing is to do your searches as soon as possible. This is obviously where we can step in. We would advise you to conduct clearance searches in relation to any really important brands, company names, and that would involve checking all of the EU registers, some of the national registers as well, to ensure there are no identical or confusing rights. Subject to clearance there, obviously go ahead and register. And I've worked with a number of startups in the last year who had that same issue. They came to me asking for a trademark registration. We found from our own research that they actually were infringing someone else's rights and they had to rebrand effectively then and there. But as I said to them, it's better to do it now than to wait a couple of years, be hit with an infringement claim, obviously all the cost that entails. There are other IP rights that might affect your businesses. If we look at something like copyright, which is it's an unregistered right, which means there's no register of interest in the UK. This would cover rights like literary works, artistic works. Literary works is pretty broad, so it would cover any kind of text on a website, it would cover marketing materials, even covers computer software, source code. The copyright subsists automatically, so as long as you satisfy various qualitative criteria, so it has to be original. You have to invest some kind of skill and judgment in the exercise of the creation. Then the copyright will subsist. Now, obviously, having a sort of a unregistered right is great in the sense that you don't have to pay the formality fees associated with that. But the downside is, when it comes to enforcement, obviously there's an obligation on you to fully justify the right that you're claiming, relying on. So that would mean providing the original design documents, copies of the original software, evidence in the original data creation, the person who created it, and also the owner. So it can be quite onerous. So with companies at the early stage of their life cycle, it's obviously very important when you're developing IP to think about these things as you go along and to keep a kind of a dated and stamped record of the IP you're developing. Turning to sort of what IP doesn't protect, it doesn't protect ideas, it's just the expression of ideas. So to kind of give you a basic example, someone like Deliveroo, who've obviously developed quite a unique app to enhance the takeaway experience. If I went away and just developed my own platform, which would enable users to order food through a smartphone app, that wouldn't infringe Deliveroo's copyright or design in any way. But if in that process I appropriated in their software source code, that clearly would be an infringement of the rights. So there's an analogy about sort of a recipe and a cake. So if you think about a recipe, if I was to write out that recipe word for word, that would be an infringement of the literary copyright in the recipe. But if I made a cake to the recipe, that wouldn't be an infringement. It's just the underlying idea which I'm trying to produce. Sort of finally, there's a couple of pointers. I mean, Nick touched on some of them in terms of what to do with the creation of IP in the workplace. So obviously it's important to distinguish between an employee who creates and an outside contractor. As Nick said, look at your employment contracts to determine what provisions apply to an employee. There are some statutory provisions which would apply in the absence of contracts, but they're not always as generous as you might think, and there are certain IP rights they don't catch. Obviously, external contractors, if you outsource your kind of coding to someone, general position in the absence of a contractual arrangement is that outsourced individual, the commissionee, will actually own the IP in that right. So you are granted under law implied license to use the IP right, but it's obviously quite a restrictive freedom. So again, it's always best to ensure that is contained within your contract with the contractor. If it's too late and you've already done that, well, obviously you can seek to assign those rights back to the company. That can be a little bit tricky in terms of leverage, but obviously if you have an ongoing relationship with that person, it's something that is possible. Nick already discussed a few other provisions within the employment contracts, but when we're looking at ideas, protection of ideas which aren't protectable as IP rights, it's very important to have things like NDAs in your employment contract so that your employee can't jump ship, go to a rival and disclose all of the kind of the secret recipe. Similarly, when you're dealing with partners, investors, people you're pitching your idea to, it might be a nice idea to have them to sign up to an NDA. Of course, in terms of the leverage between you and an investor, they may not be willing to do that. But if even a simple email drafted saying, I expect these discussions to be confidential, that would give you a cause of action under the law of confidence, which is a common law cause of action in the UK. And similarly on the protection of the idea, point 2, restricted covenants. Again, the key point for someone with an idea is you want to retain your first to market advantage. And if you have an employee just jump ship with your idea, obviously that's fairly fatal. So restricted covenants will prevent that. So in conclusion, I guess say just make use of the full suite of IP rights available. It's best to deal with it now rather than to kind of think about it down the road. I know it's obviously relatively expensive, especially in early life cycle, but it's going to end up being more expensive if you leave it.
Brilliant. Thank you very much.